Thank you, Mr. Chairman. I haven't heard anyone say that 702 is not essential to our national security. And I believe it is essential to our national security. So I'm delighted to hear that people are saying that, not claiming that we can do away with it. But what you're also hearing is a lot of skepticism, even distrust of the intelligence community based on abuses that have been well documented. And as you know, once that trust is lost, it's hard to earn it back. So we're at a little bit of a crossroads here. I'll remind you that it was just a few years ago where we tried to reauthorize Section 215 of the Foreign Intelligence Surveillance Act, and we're unable to build a political consensus to do that. So I do believe your testimony that this is important to our national security. So the question is, how do we work together to regain the public's trust and the confidence of members of Congress will be asked to vote in favor of some reforms. Mr. Abate, you've talked about the work that's been done at the FBI, and I had the opportunity to go look at how the FBI's reforms, not the ones you mentioned today, but the others, in terms of querying FISA information, how those work. Would you have, or the FBI director, have any objection if those reforms that you've announced, that the FBI's announced, were codified and written into the law as opposed to just policies of the agency?
Thank you, Senator, first for visiting with us at FBI headquarters and taking the time. We would not have any objection at all from the FBI standpoint to codifying any and all of the reforms that we put in place and future ones as well.
And Mr. Abate, I was struck by the fact that when the FBI is doing an investigation, an agent's not just sitting down and doing a query of foreign intelligence information lawfully collected. You're actually engaged in querying more than 100 different databases. Is that correct?
Yes, Senator. I don't know the exact number of databases, but we do have quite a few.
And so this is not agents sitting down and just looking at foreign intelligence surveillance. They're looking for all the data points to be able to put together an investigation into potential intelligence vulnerabilities or to pursue perhaps crimes. So there has been some suggestion, and I'll throw this open maybe to Mr. Olson. There's something known as Executive Order 12333, which again, by definition, is something that the President of the United States has done without congressional input or interaction. But there's been a question raised as whether, if 702 were to go away, does Executive Order 12333 provide the tools necessary to protect our country?
I'll answer, and maybe Mr. Fonzone might have an answer to this as well in his role as general counsel for the DNI. But the short answer, Senator, is no. And the reason the answer is no, and flatly no, is that Executive Order 12333 does not allow for the critical piece that 702 does, and that is compelling the support and compliance of private electronic communication service providers. In other words, the real genius behind Section 702 was, yes, it's focused outside the United States on non-U.S. persons, but it also allows the government to compel the assistance of a provider inside the United States, which are often the ones that are providing support or communication support to the individuals that we're targeting outside the U.S.
Mr. Cohen, obviously Congress is very much engaged on a bipartisan basis in supporting the Ukrainian people in light of the Russian invasion of their country. And the other sort of major issue that seems to enjoy broad bipartisan consensus is defending our country against the aggression of the People's Republic of China. Could you speak to how 702 is important in terms of both of those matters?
Senator Cornyn, I will say for both of those efforts, 702 is involved. I can go into more detail when we go into closed session, but we and with our colleagues in the intelligence community rely on 702 to identify foreign intelligence information that is useful for our analytic work in providing products to Congress and to the administration in the Ukraine context, understanding what's happening there, as well as a whole host of products that we write with respect to the challenge that we're facing from the People's Republic of China. But I'm happy to go into more detail in the closed session.
Thank you. Thank you.
Thanks, Senator Cornyn. Senator Blumenthal.
Thanks, Mr. Chairman. I will be interested in hearing how 702 has been useful with respect to both Ukraine and China. I can certainly understand as to China. I wonder if you could give us a little bit more, even in this public setting, about how it's been important to our assistance to Ukraine in its fight against Russia's criminal, murderous aggression.
Senator, let me take a shot at that, but mindful that I do think that some of the real substance would be better discussed in closed session. And so what I will say, and picking up a little bit on the answer to the prior question, is that our adversaries, whether they're Russians, Chinese, Iranians, North Koreans, terrorist organizations, make use of U.S. communications service providers. And if there is a reason for believing that we have some foreigner operating overseas who is using the communication service that is provided by a U.S. service provider, we, or more likely the NSA, will target that foreign person overseas to collect the intelligence collect those communications. We can then query the database of information that is collected on those foreign persons overseas. We run queries, NSA runs queries, obviously FBI runs queries against this database of information that is collected when it is reasonably likely to retrieve foreign intelligence information. And we do that in the Ukraine context, we do that in the context of the People's Republic of China, and in other contexts where we have national security.
And in the Ukraine context, we can play a part in supporting Ukraine through sharing our intelligence, correct?
There's a whole host of ways in which we're supporting the Ukrainian government with intelligence sharing, and it involves the full swath of collection that the United States is involved in.
Let me ask you, as you may know, and I think we've talked about it in our conversations in my office, I've been a longtime advocate of some more robust adversarial process within the Section 702 FISA procedure. In 2015, Congress took an important step in codifying the amicus responsibility. My numbers are from 2015 to 2020, there were 1,200 FISA applications, but just 19 amicus appointments. And in 2017, the only amicus at the time with significant criminal defense experience in the FISA context resigned because he hadn't been assigned to a single case. Those numbers tell me that the present amicus process is not providing really robust or sufficient adversarial procedure. When we all know as lawyers that our justice system thrives on the adversarial procedure. This area is the one part of our justice system where we have no such adversarial process because the subjects of 702 collection likely will never learn that they've been the subject of this process. So what is your position on this issue? I think I know what it is, but I'd like you to state it for the record, if you would, sir.
Senator, is that a question for Mr. Olson or for me?
Whoever would like to answer.
Why don't I turn it over to Mr. Olson, who
I'm
handles
happy to answer that
litigation?
question, Senator. I represent lead the National Security Division. We represent the government before the Foreign Intelligence Surveillance Court, so we're directly involved in the process that you describe. First, we are open to reforms, as I said at the beginning, that preserve the essential effectiveness of Section 702. So if there are reforms, for example, to the FISA court process, we're happy to engage with you and other members of Congress as we think through how those would work. When it comes to the amicus process, the FISA court can ask for an amicus to be appointed in any case, and they do so in any case involving a novel or complex interpretation of FISA. And that's the cases that are the hard cases, where they do have an adversarial process through the amicus appointment. The vast majority of FISA applications are basically the same as the ex parte process that occurs in a Title III criminal application, which is not an adversarial process, but rather criminal.
It's not, but eventually there is likely to be a challenge.
That's correct.
And in this instance, there's likely to be no challenge. And so the privacy interests arise not only where there's some new, major, novel interpretation of law, but as you well know, you know a lot more than I do at least, the case-by-case decisions often turn on interpretations of law that are challengeable. And that's why an adversarial process would provide a lot of reassurance, I think, to this committee and the American people.
Again, we're open to having this conversation and engaging with you on this. It is my view that the vast majority of FISA applications are basically facts against the probable cause standard. They don't involve novel interpretations of the law, and they are done on a level of with a degree of urgency, multiple times a week, that does not lend itself to the sort of adversarial back and forth process that an amicus would introduce, and so there's some serious risk to having, for example, an amicus in every case.
Thank you.